Good morning, everybody. Welcome to the Zoom meeting for registered sellers on the new administrative rules. We're going to go over the new rules as they pertain to registered sellers. I'll do a quick summary of all the rules, significant changes to the rules, and I want to go over some ground rules. And like I said, we are recording this and it will be posted on the website. And I want to bring to focus a couple things regarding contracts and the financial surety devices that are required by registered sellers. So welcome, and we will get started. Let me share my screen. Oh, before I do that, I want to introduce the staff that we have on the call. Also, Donnie Featherman is our program manager. Amelia Spinner is our administrative lead for the program. We also have Yesenia online. Many of you have dealt with her. She is in charge of the installers and the foundation program. I saw Deb Kosman online. She is the primary for factory built and factory built non-residential program. Many of you may have worked with Bev in the past. Deb is now in Bev's old slot. And Christina Wilkes, was she able to make it today? Donnie, Amelia? Okay, Christina Wilkes is also on the line. She's the new tiny home program coordinator. So we are fully staffed on the coordinator side. We're pretty much fully staffed. With inspectors, I'll talk a little bit about building codes and standards and where we are. But we've got team members on the line, and I want to make sure you guys get to meet them and have their resources. I've got a slide at the very end of this that has everybody's contact information, and the PowerPoint will also be attached to the website for you guys to take a look at. But give me a week or so to get that done. All right, I'm going to share my screen. Can everybody see that screen? The welcome slide? Yes, no?
Looks great.
Yes.
Okay, thank you.
Yeah.
We also have the chat feature going. If you want to ask questions in the chat, you can. You're welcome to pop in at any time with a question or raise your hand. We'll call on you. Amelia and Donnie are adding new participants as they pop in, and I'm going to get into the presentation now. All right, so we have certain, like I said, I want to talk a little bit about some ground rules. I'll talk a little bit about building codes and standards. I'll talk about the approved codes and then the new and modified rules, especially focusing on registered sellers. Then we'll have some discussion and wrap up. So one thing I mentioned at the start of every one of these stakeholder meetings is that we cannot change statute. Legislators make the laws for Colorado, and we follow them to the best of our ability. So if you have a problem or a concern, or you don't like the statute, you can certainly mention it, but we can't change that. That takes legislative action. We can only we cannot change the approved rules at this point in time. If something doesn't work, we can consider that in the next rulemaking process. My guess is we'll do a rulemaking. We're still trying to decide if we're going to do a rulemaking next year, but I think we may have to. But the rules have been approved, and we cannot change them except by emergency action, and that's not a fun process for anybody to go through. We're only addressing Colorado law and Colorado rules at this point in time. Stuff going on out of state is, again, outside of the scope of the program. Just a brief reminder on what our controlling and guiding documents are. I mentioned statutes and laws before. We are guided by Colorado Revised Statute 2432-3301 through 2432-3329. There is sections in that statute that pertain directly to registered sellers. And so I would recommend that you guys read those. I have copied some of that over because I'm not sure everybody has read those statutes. But again, it's your responsibility to read those revised statutes. The reason we did the most recent rulemaking was what they call the Tiny Home Bill, HB 22-1242, that was signed into law. And we did a rulemaking process to make those changes. It did a lot more than just change everything in our life to and tiny homes. It added some new requirements for foundations in areas of the states, an area of the state that doesn't have a building department. That'll be very important to you. And I'll tell you why it's going to be important to you in just a couple of minutes. It also added some wildfire mitigation risk for those local communities that have adopted local building departments that have adopted a wildland urban interface code or something similar. And that's going to be important to you guys too. Then, of course, after that bill was signed into law, we began a rulemaking process. And we actually have a technical advisory committee that's made up of 15 different members. And we go through these rules in a lot of detail. We take that opportunity to revise any rules that need clarity. But our primary purpose is to implement the new law as it changes the statute. And so there's like I said, 15 members. There's a couple of manufacturers. There's a couple of, I think there's a registered seller. I think there are 2 tiny home people, one from, there's also one from the state plumbing, 3 building code officials. So all those, and an architect, a factory built structure expert. And so anyway, if you're interested in that, I can get you more information. But that rulemaking process takes about 9 months because there's certain gates that we have to go through and notifications that we have to go through. And so all these draft rules are worked up and then they're sent out to the communities, the stakeholder groups, as well as being available to the public for any comment. What I have done on a website with these administrative rules is I've got the new administrative rules. That's the clean version, pretty cover page, the entire thing, table of contents. But I've also put a red line copy up there. If you want a quick reference on what changed from then last year to this year, take a look at this red line copy. I use it as a reference guide every single day. And so I will leave that up for a few more months, but you may want to print out a red line copy and be sure, like I mentioned before, you're responsible for reading statute and the administrative rules in their entirety as a registered seller to this program. For those of you that are not real familiar with building codes and standards, we take care of anything that's factory built that is either built in the state or out of the state, coming into the state for both residential and non-residential customers. That includes modular and tiny homes and HUD code homes that are coming in. We do not change. We don't have inspectors on the HUD code homes when they're manufactured. Each state has its own program set up for that, and we have no HUD factories in the state, but we are responsible for the installation of those homes, and the registered sellers need to be, that are selling HUD homes, need to be registered with the state. just the way that it goes. We do plan review, we do inspections, and then we have the administrative side of the program that makes the world go around, right? We look at, for modular and tiny homes, we look at the construction plans to make sure they're in compliance with our state codes and with local jurisdictions for wind, snow, design, winter design temp, and the most recent one is wildfire risk. Then we have third-party agencies, or our out-of-state manufacturers are required to have a third-party agency in order to do those factory inspections wherever that factory is. For factories in Colorado, they can either hire a third-party agency, or they can pay the Division of Housing, Building Codes and Standards to do those inspections. We also do complaint inspections, and I think that's very important, and I'll talk a little bit about that later. And so if a consumer is not happy with their home, or they feel there is a construction defect or deficiency, or a installation defect or deficiency, they can come to the Division of Housing. We will then do an investigation, an inspection on that home, and we send correction notices if necessary to the manufacturer and to the installer, depending on whether it's a manufacturer concern or an installation concern. Sometimes we get complaints on registered sellers not following the contract, or or failure to deliver, and we'll talk about that a little bit more. But those complaint inspections are important, because we often find that the consumer, the homeowner, does not know who's the responsible party. And sometimes it's a little difficult for us to figure out who's the responsible party, but everybody has worked very well with us. Our manufacturers work well with us, the registered sellers work well with us, and the installers do also. So, but the consumer, that homeowner, doesn't often know. And so, and we don't work on behalf of, I make this clear to everybody that files a complaint, we don't work on behalf of the homeowner. We work to make sure that the unit is safe and built to code, and we make sure the installation is done correctly. Once we open a complaint, and sometimes we see this, in addition to complaining to us, the homeowner files a lawsuit against everybody, right? Because their home isn't right. We don't get involved at all in the civil matters. If we find, let's say, for example, an installation complaint, until that correction notice is cleared, that home is not a certified unit in the state of Colorado. What that means is, if the repercussion of that is, if there's a civil lawsuit where they settle and then they want us to close our complaint, our answer is no. This has to be fixed. This foundation or this installation issue has to be fixed, or this construction or manufacturer defect has to be fixed. So we often say, hey, we get emails from consumers, homeowners saying, hey, we've settled, I want to close my complaint. It's not your complaint. I told you it wasn't your complaint. It's a state complaint, and we still have to get this fixed. Because that home might be sold sometime in the future, and if it has a deficiency or a correction notice on it, then that home was not built right or set right, and that will affect future homeowners of that unit in the future. So we want to make sure everything's right with the unit. Happy to dive into that more at some point in time. We did not change the building codes. This doesn't affect registered sellers much. We did not change the building codes very much. The base codes are still the 2018 building codes, except the 2015 IECC, the Energy Conservation Code. That's still our base. We did tweak some amendments to that. So if you're interested, be sure and take a look at those rules. And again, I'll hit some of the highlights, but I want to give you guys some time at the end so we can have discussion on your roles and responsibilities as a registered seller and interactions with our staff. Again, every home for Colorado has to have an address on it when we look at the construction plans. That works a little different for lot models. Lot models have to have an address before they're clear to go. But in general, we see a specific address for a unit. We make sure the wind load is right, the snow load and the design temp is right. The fire safety components, if there's fire suppression systems required in the jurisdiction, we flow that through, make sure that we inspect that, and then the wildfire risk is new. For those of you that are familiar with our rules, we have 7 sections on the rules. If not, be sure and take a look at it. Rule 1 is the definitions. Rule 2 is codes and standards. 3 is the fees. 4 is the manufacturers. 5 is the sellers. That's your most important rule. And then Rule 6 is installers, and Rule 7 is enforcement. Rule 3 on fees. Your fees are set by statute. So we can't increase your fees on you until we see statute change. Rule 1, some of the terminology you may want to take a look at. We changed some of the definitions, added some, changed some. What used to be called AC, alternative construction, has been replaced with on-site construction, OC. So where you're familiar with AC items, they're now OC items. So if you guys can start calling them that, that'll help everybody out. We changed the definition a little bit to a permanent and temporary foundation. So you may need to look at that. We are now allowing remote inspections by third-party agencies. We're finalizing some of our procedures on that. For tiny homes, we added the requirement for a vehicle chassis. And then wildfire risk, we clarified that from state statute. The seller definition is in statute. It's not in the administrative rules. Be sure and read that definition. It's CRS 2432, 3302, 32.5. A seller means any person engaged in the business of selling manufactured homes to be installed in Colorado, or tiny homes to be occupied or installed in Colorado. Rule 2 is code and standards. Again, that's not going to affect a lot of people on this group. We have state-approved codes for IBC, IRC, and we tweaked those a little bit. Some big changes for tiny homes in Appendix Q of the IRC. No significant other changes. The state has updated the National Electrical Code. We're going to get out a technical notice on that. That went into effect on the 1st of August. So manufacturers are starting to prep for the changes required by that. And of course, we don't change any of the federal standards for HUD code homes. We did add a late re-registration fee of $100. If you're late in your re-registration, you may get assessed a $100 late fee. Some other fees for, like I said, we kept fees the same pretty much, but added a couple late charges. The other fee that we wanted to bring to light would be the, and I'll talk more about the foundation inspection fee in a minute, but a cancellation fee if we are on our way to a site to do an installation inspection or an oversight inspection, and that is canceled, there'll be a $100 fee for that. again, just minor fees. Rule 4 is the manufacturer section. We had been using terminology of registered factory. We've changed that to try to rewrote the entire rules to kind of focus on the registered manufacturer or certified manufacturer. Again, if any of these, if you want to read through the changes, they should make sense to you. If you have any questions for us on that change, we went through Rule 4 in detail on that manufacturer stakeholder meeting a couple of weeks ago. Okay, now we get into the meat and potatoes, and that's Rule 5. Any questions on what I've gone through very quickly so far? Okay, let me know. So we added tiny homes again as a building type that falls underneath the program. So manufacturers of tiny homes, if they're selling direct to the consumer, also have to be a registered seller. Actually, of any type of product, have to be a registered seller also. And we'll talk about that. But tiny homes, if you guys are not familiar, we're starting to see some interest in tiny home villages. We're starting to see some interest from manufacturers to run state certified tiny homes. They will get an installation insignia, and they will also get a certification insignia, just like a modular unit. Okay, except it's a different color. So if you want to start selling tiny homes for people, make sure you'll follow the registered seller rules here. If it is a state certified tiny home. Now, there's a lot of confusion out there about what is a tiny home and what is not a tiny home. If it's built to the RV standards, if it has an RVIA sticker on it or some other, if it's built to ANSI 119.5, then it's an RV. It does not fall under this program. We're still going to see RV manufacturers marketing tiny homes in the state of Colorado. I'm trying to make a designation, a differentiation that the state certified tiny homes are built for long-term occupancy. They're built to the International Residential Code. They can go on a temporary or a permanent foundation. And so if you get questions about that, there are FAQs on our website for consumers, manufacturers, local jurisdictions. And just make sure that the consumer knows that if they're looking for a tiny home, that they can get a certificate of occupancy or consider a long-term dwelling, then they need to look for that state certified insignia on the unit. Any question on tiny homes without spending an hour going through all the details on tiny homes? But are there any general questions on tiny homes right now? Okay. Rule 5.2 is a repeat of what we put back in Rule 4. The manufacturers who sell direct to the consumers must register as a seller. Another one in the administrative rules that we'll talk about in a little bit in detail is 5.7. All bonds, letters of credit, or certificates of deposits must include language that the Division of Housing be listed as the agency that call the bond CD or COD if necessary due to an enforcement action. We're still seeing some bonds come through with the Attorney General's office as the payee. We kick those back. Save yourself some time and trouble and make sure that the Division of Housing is listed as the payable agency. 512 is the new rule that's going to affect you guys, I think, the most. There's a new requirement for sellers to notify buyers in areas of the state without a building department that they must get the foundation design approved and inspected by DOH. It was a statutory change in HB 22-1242 that requires all foundations for factory built structures, that's residential and non-residential, and multifamily, that if they are in an area of the state, and there's 17 counties that don't have a building department, if the foundation plans have to be stamped by a licensed design professional, that means an architect or an engineer, and the foundation itself must be inspected by DOH. And that's Donnie's team and his 3 inspectors. I think that's not a bad thing. I think that most of our complaints in areas of the state that don't have a building department, about half of them trace back to foundation. Therefore, us inspecting those and making sure that they are done per our codes and requirements is going to cut down on the number of complaints and cut down on the number of headaches you get on selling in areas of the state that don't have a building department. There's a requirement in there for you to pass on this notification in your contract to the buyer of the home. So make sure that you either have an addendum to your contract or you incorporate it into the contract effective immediately, actually effective July 1 of 2023. So make sure that you are doing that going forward. Stuff that you've got under contract already, we're not going to go back and look at that. But if you want to notify, if they haven't poured yet and you want to get them, have them go through the program, we will do that. We've also told the installers that if they're installing in areas of the state that don't have a building department, to check with us before they install the home on a foundation that's been poured by the homeowner or a contractor. For you sellers that take care of that extra construction work and the foundation work and everything else in areas of the state, have your contractor send us those plans and we will take a look at that. All that's going through Yesenia. Now, I expect a lot of questions at this point, or at least some questions at this point. Is that fairly clear to everybody? Are there any questions you have on the foundation requirement? You can unmute yourself and ask a question, or you can put it in the chat, or you can raise your hand. Okay.
Hey, Sam, can you hear me?
Yes, I can hear you.
Hey, so maybe we just share with people how they figure out, like, I don't really have a whole bunch of customers that don't know that most people have building departments. I personally haven't experienced people or, places where they don't have building departments. I'm sure they exist in Colorado, right? I'm sure there's several. I assume they just go to their local county and their county can tell them.
Yeah, if
Is this like rural Colorado?
this is
that what it
very
is?
rural. This is Baca
Like San
County.
Luis, Colorado. You know what I mean? 81134.
Yeah, Baca County does not have a building department, right? So
Okay.
you're selling to somebody down in Baca, Springfield, Vilas, down in that area.
Oh, like Costilla County and some of those other ones?
Yes, yes.
Okay, so
Jurisdictions that do not have a building department. I mean, the seller would know if they're pulling the permits or taking
Yep.
care of the foundation or
Yep.
on-site construction. The most sellers are going to know. And Christina Wilkes just put up a link to that. There's a list of the counties that don't have building departments. You can go check that out. It's on our website.
Oh,
But
okay, cool. Awesome. Thanks.
they don't have a building department.
Yeah.
And I know some of these counties are starting to try to stand up building departments. So that list is not, make sure you know, check with the local county government. You can generally find out from their website. You can generally call the county administrator or the whoever is taking care of the administrative side on the county, and ask, do you require, do you have a building department? And they'll tell you yes or no. They may
Okay.
still have a permit requirement.
Right. They do.
But they may not have a building department that can do the plan review and the
Okay.
foundation inspection.
Okay, that's good to know. So just so everybody else knows, from a builder perspective and a builder best practice, obviously it's just going into our contract as an addendum just to educate people, because we all know that we don't know where all these houses are going all the time. Just because a tiny house leaves my shop doesn't mean I know exactly where it's going all the time. I may know it's going to head out to an RV park or somewhere, but I don't know where it's going to end up in Colorado. So I feel like it's just a best practice to educate your customer, period.
Yep. Thank you. Any other questions on foundation? Okay. Rule 6 was installations. Again, here's where I mentioned, and we had this same slide for our installation installers focused meeting. Installation areas the state without a building department must be installed on a foundation where the design has been approved by DOH and the foundation has been inspected by DOH. And they have bonds too, so that's the same requirement for listing DOH. The enforcement section of the rules only had some minor grammatical changes. Here's that resource slide I talked to you about. Again, I'll get this posted. The manager of the program is Donnie. Tiny Home Program Coordinator is Christina. And then FB and FB&R Coordinator is Deborah Kosman. Okay, now into the nitty gritty on a couple of things. I want to talk about the financial sureties, which is this slide. I want to talk about your contract requirements. I want to talk about complaints, and I want to talk about audits. And then, so this is the general discussion part. You guys jump in with questions. As I mentioned, whether you have a bond, letter of credit, or CD, it must list the Division of Housing as the entity who will draw upon that. It must be a minimum of $50,000 for deposits received. And it must cover all deposits received by the homeowners. So that minimum is just your starting point. If you're keeping more money for deposits than $50,000, then you need to make sure that you bump up that bond or that financial surety device in order to cover all those deposits. There are some exceptions to deposits. This is the Cliff's Note version of these. Be sure to read, and these are in statute and in the rules. So make sure you read the statute and rules. So actually, this is the, I think these are in the rules. The exceptions to the deposit is if you keep money in a division approved escrow or trust account. Don't ask me if we have an escrow or trust account, because the answer is no, or don't ask me for that information. If you have a escrow or trust account you would like the division to approve, we could maybe go down that road. But we don't have anybody actually doing that in that number 1 exception. The portions of the deposits of the down payments that are distributed within 30 days for specific services that are detailed in the contract, either clearly invoiced to them or sent to somebody or sent to the manufacturer for construction, is not subject to that $50,000 limit. And then you have another line called nominal sales promotion amount billed to the purchaser for the purpose of holding a pricing level. So don't think that it's every single amount you get for the deposit. It's the amount you're keeping for that deposit, the stuff you sent to the factory, the other expenses that you have are not subject to that $50,000. And again, if you have more than that, you need to bump up that amount. With that said, and here's where I'm going to throw in the audit piece. Statute says that we will audit these accounts every 2 years. We're going to start doing that sometime this year. We will ask you to prove, to give us a financial statement on your deposits amounts that you're holding and what you've paid out for manufacture of the home or other approved expenses. So get ready for that. We will send out a notification before we start that with what we expect to see when we ask for these audit documents. But it's pretty clear we're supposed to be doing it. We'll want to make sure that you're and right now your registered seller registration is kicked back if the Division of Housing isn't pulled on there. Your primary reason for these deposits, again, you also want to take a look at the enforcement section. What we've seen so far is that it's a non-delivery of a home. It's rare. We don't deal with that a lot, but it has happened. If the homeowner has paid a bunch of money for a home and the registered seller doesn't deliver it, then we can call that bond in order to try to make that manufacturer or make that homeowner whole. The most seller app, Christina, thank you. She also added the most recent application with detailed instructions on there. Be sure and take a look at that. And then, of course, like I said, reach out to Deb Kosman or Christina Wilkes if you have questions. Manufacturers, the same requirement will apply to you. Any questions on the bonds, letters of credit, or CDs? Staff, anything you guys want to add?
I do, Sam.
Okay, Donnie.
Just kind of wanted to add just real quick. So the bond requirements that are in the rules for seller requirements is, you have to have that minimum $50,000 bond or letter of credit, or there's three different financial certificates that you can have to show that you have the $50,000 bond coverage or the $50,000 coverage itself. You don't have to have anything above that 50,000 unless you're collecting more than 50,000. And so there's two ways you can do that. You can either bump up that bond, or you can create the escrow account for that additional collection that you're doing. But if you are only doing 50,000 or up to 50,000, and you're never going to go over that 50,000, you don't have to have escrow. And so in those cases, what we ask for is just an affidavit saying that you will not collect more than $50,000 in deposits. And if you do, that you'll automatically notify us within 30 days that you have collected more than $50,000 and that you got either the escrow or you increase the bond coverage. All right. The other thing too is that we're running into is we got one parent company that is registering, but they have all these satellite dealers that are around Colorado. It's important that you list the main, I guess the main office of that seller company, and then list all the different satellite companies, because we create separate accounts for each seller satellite, basically, or basically just the additional I guess businesses that are operating under that name. Yeah, there we go, locations. So each account we'll have to make sure that they are covered under that same bond coverage. And then also, if there is escrows, so like if that's just for instance, if you have one main office, but you have 6 or 7 satellite offices, and you're saying that you're only collecting a minimum $50,000 deposits, if each satellite is collecting money, you might exceed that. So you have to make sure that you have enough coverage to cover all those operating businesses. And that's it. I don't know. Hopefully that was clear enough for you.
Donnie, those are good points. And the other thing we have to do internally is if these satellite locations are their own LLC, and you're not going to be responsible for them in case of a non-delivery of a home or a home that is over 90 days late from the promised delivery date. If you're not going to be responsible for them, let us know, and then we'll take a $50,000 bond from them too. It's the only way I can see making that work. And we'll dig into that a little bit more.
I have a question.
Okay, go ahead.
2 questions, actually. I'm sorry. It's our company's time for renewal by October 1st. So, first question I have is, I listed our escrow account on the renewal application, and I do every year. So does that count as it being division approved escrow account? Because I've listed all the information where the DOH can call and confirm the information by way of account number, routing number, bank's phone number.
We would need to be able to call on this escrow account. So I guess that is something that we need to work out and make sure that it's an approved escrow account and we can call on it in case of a non-delivery or a failure on the registered seller side. Work with us on that, reach out to us, and we can get that figured out.
Okay.
Hey, Steve, are you talking about a continuation letter?
I'm talking about the escrow account. I had a second question about the bond, but I was talking about the escrow account specifically.
So the escrow account, are you just saying I have an escrow account, or are you showing actual proof, like a receipt, showing that you do actually have an escrow?
On the application, it said to have a bond, and I sent in a copy of the bond, and that will be my second question. But I also listed our escrow account, routing number, account number, and all the bank's contact information. So my question was, does that mean that it's division approved? And I'm hearing from Sam that I need to reach out to you guys and figure out a way where you can contact the bank and say, if something happens, we need to have access to this money.
Yeah. So, Christina and Debbie, correct me if I'm wrong here, but we typically ask something from that escrow company that you have an account with them. It's not that you're listing something on your application. We actually need something from that escrow account or that escrow company that you do have an escrow through them.
Yeah, I'd be happy to provide whatever. I went through the application and maybe I missed it. I just didn't see where I had to attach anything showing I had it with Community Banks of Colorado.
So
Okay,
Donnie, we've always required the original bond, but I've never had to have anything more than just escrow contact information. I don't know if escrow provides something similar to a bond that we need to consider keeping in file.
Yeah, so I guess we'll just have to discuss that a little further then, because the reason for asking for the escrow is not only providing it, but also showing proof that it's a true escrow coverage. It's not just, some information that you put together to, I guess, fill in that blank, right?
No, I guess, yeah, what is the definition of a true escrow account? I get asked this all the time. Does that mean we can have interest accruing on it, no interest accruing on it? I've been looking through all this state stuff, and I'm not sure I have a clear definition of that.
Okay, so I guess if you can write down those specific questions of what details you're looking for, and then we can have those conversations, because it does not specifically say in statute or in rule. It just says that you have to have an escrow,
I think we can add that to the rules next time, but let's go ahead and put up a procedure on what we expect to see in the escrow. And it'll actually help us, I think, to say, yeah, we want an escrow account. We want a statement from the escrow account company, whether it's your bank or whatever it is, that the Division of Housing is listed as a co-owner of that account in case of an enforcement action, and that we could call upon it. Whatever that language looks like. And, you might be able to help us out by being our test site on this, because I really didn't think we had that many escrow accounts out there. So
It's very rare we take deposits that total over 50,000, but
Sure.
just in case, we do have an escrow account. And we let
Okay.
our customers know that too, so.
and who is this?
I'm Steve with, it's actually Rocky Mountain Base Camp or Rocky Mountain Modular Homes. I also work for Above Tree Line Construction, so I'm on that Zoom account right
All right, great.
now. I have one more question about the bond really quick. I'm sorry to take up too much time.
Okay, go
but
ahead.
On the bond, I probably just caught that I sent that incorrectly when I turned in my renewal, but I have a rider that says it names the state of Colorado as the authoritative entity that can call on the bond. Can I submit that rider separate of the bond application I sent in, or the renewal application?
So the rule specifically says to state that the Division of Housing is the
Right.
entity that can pull from that bond.
It says that on the rider. I must have said that wrong, but it says that on the rider.
Okay. Yeah, so like, again, if you're doing an extension or anything, as long as you have the original letter of credit or certificate of deposit or the bond coverage that has all the information in there, and it says in there that the division has access to that in the event of that we need a withdrawal from that account. That's fine. If the writer is writing something that's an extension of that, that's fine, as long as it says the Division of Housing. We don't want it, because I think you said the state of Colorado.
Yeah, I'm sorry. It was the Division of Housing.
Okay,
State
good.
of Colorado Division of Housing.
Okay. Christine?
Thank you.
So Steve, I think you've got to renew your bond anyway for the seller registration next month. So can your financial institution just reissue that bond with Division of Housing listed as the beneficiary, and then you won't have to worry about the rider?
Yeah, I already had it renewed and they sent the rider separately, but I'll just get with my agent today. One of the things was I got your email where it states that you can send it in through the portal, but my agent wasn't getting that portal working for the bond. Has anybody else had success with that?
When I click on that portal link, it doesn't work for me either, Steve. So we've got IT working on getting that fixed.
Okay, well then what I'll do is I'll just get with my agent today, get the whole bond just reworded, and it's already been renewed, but then I'll just get that updated bond to you guys as fast as possible.
Thank you.
We do need the original bonds mailed in.
Oh, okay.
That's fine, I can mail it in.
Okay.
Good discussion. Other questions on bonds, letters of credit, CDs, escrows? Okay. We'll jump to the next slide. Here is the other one that I want, and I copied this from statute, guys. I don't normally do this. But in a couple cases, I've during the complaint process, I found out that we're not meeting, we being the registered sellers, you guys, are not meeting the contractual requirements in statute. It's very specific. It is required. The seller must provide a contract in number one. And then it has to have that the purchaser may have no legal right to rescind the contract, absent delinquent delivery, or the existence of a specified right of rescission set forth in the contract. If required to maintain an escrow account, the seller has a separate fiduciary account in compliance with board rules and a letter of credit. That needs to be in the contract. C, that an aggrieved person may file a complaint with the division against the seller for a refund of any payment held in escrow. And D, that an aggrieved person may bring civil action pursuant to the Colorado Consumer Protection Act to remedy violations of seller requirements, and that's part 33. However, damages are limited in accordance with section 61113. That is the first page of stuff that needs to be in your contracts, right? And in some of this notification stuff, it can be an addendum to the contract. I don't care, but it needs to be explicitly given to the buyers. Page 2 of this, and I know this is a very busy slide. Contract for sale must also include either A, a date certain for delivery, or 2, a listing of specified delivery preconditions that must occur before a date certain for delivery can be determined. So you can either say, yes, your house will be delivered on such and such a date, or you can say that your home will be delivered on after the foundation is done, after the home is delivered from the manufacturer, however you want to word it. There's a couple ways to go there, but that has to be in the contract. And then be sure and read 2B. I'm not going to read it to you. A statement that if delivery of manufactured home is delayed by more than 60 days after the delivery date, that you're providing a per diem living expense for them. We've not seen that in some of the contracts we've looked at. And then C, agreed upon location for delivery of the manufactured home or tiny home to the purchaser. And then any seller in 3, any seller who fails to provide a contract as required by this section is subject to the suspension or revocation of the registration by the division. We don't want to have to do that. We would rather you change all your contracts now and change all your, and I did have a registered seller where I asked them to change all their contracts that were currently existing. They squealed a little bit about that, but they understood the need and the legal requirement to do that. So be sure and take a look at your contracts and make sure they're compliant. We will also be auditing some contract compliance this year. We want to make sure these are right. So this is your notification that we're going to be asking for a copy of your contract. Any questions on the contract requirements? Is this news to anybody? I'm not sure. You don't have to answer that. I'm sure all your contracts are good, right?
I'm gonna say it's not news. I mean, we kind of talked about it when we were going through the process,
Yep.
but there's some specifics in there that are a little bit new, and so obviously I gotta check this verbiage and make sure my contracts line up correctly.
Yep. And remember the other thing that I've talked to you about in foundations before. You now have to notify in areas of the state that don't have a building department that the foundation has to be designed and stamped by a licensed design professional and submitted to the state and Division of Housing, and that we also have to inspect that foundation. And depending on the foundation type and where it's going in the soil tests, sometimes that takes multiple foundation inspections. Okay, good. So now we're getting ready to wrap up here. I appreciate your time. I want to talk a little bit about audits, and I mentioned that in the last 2 slides. We are going to start auditing the deposit requirements, how they're being met, and then also taking a look at some contracts. If you remember when I mentioned earlier today that we were fully staffed, Now we put that stuff off for a while because we weren't fully staffed, but now we're going to start taking a look at that. The next piece I want to talk about is the complaints. And I've mentioned that some, right? So the complaints come from the homeowners, and they don't know who the responsible party is in a lot of situations. Our team spends a lot of time on complaints, and we have enough access to the materials, the construction drawings for the unit, the installer's information, the seller's information, and the manufacturer's information, that we can generally sort it all out. At the same time, in some situations, we have attorneys trying to sort it out too. Our attorney is the Attorney General for the state of Colorado. If attorneys contact me and it's not a simple request for information, that's who they get to work with. But our process starts with a very complete complaint form, where we try to get the serial numbers, the date of installation, all the information we need, photos of the insignias, so that we can pull up all the records on that, and then we start trying to sort it out. And when we think we have a pretty good handle on what's going on, we send out an inspector to do a complaint inspection. And it may be from either, like I said, on the installer side or the manufacturer side, or in some point, it's a non-delivery of a home, and then the seller gets involved also. If the seller is the responsible party for the on-site construction, or is hiring the installer, or is pulling the permits for the homeowner, then the seller does get involved in that process. And then that's when I start taking a look at your contracts to say, okay, you agreed to do this. You agreed to pull the permits. You agreed to do the installation. You may, if you don't use a registered installer, stop doing that and start using registered installers. If you need a list, they're on the website, or you can contact us. We found that a time or two. Overall, you guys are doing a great job, and I know it's a partnership with the manufacturer. I know it's a partnership with Building Codes and Standards. Please don't think I'm just sitting here lecturing to you. But complaints takes a lot of time, and if we do it right up front, then we don't have to go spend so much time on it in investigations. And with that, I said, I don't know if Donnie or if anybody else staff has comments on complaints, but if you want to ask me anything about complaints, not a specific complaint, but our specific process on complaints, you can do that. If you have any concerns with the way that we do complaints, I think I made it clear that we are trying to make it, once we send out a correction notice, until that unit is, and that correction notice is closed, our investigation process continues.
Hey, Sam. I wanted to add, or ask a question to the people that we do have on today's chat. If anybody sells, I guess my question is, do any of you sell HUD manufactured homes?
Yes.
So Steve does. Anybody else? No? Okay. So this is kind of related to you, Steve, then. But the way that we're kind of learning as we're going. We're focusing more on this complaint process now that rules are over. The past couple of years, it's been we've been taking chunks out of our process and trying to reinforce them and fill in the holes where we need to. And so we're still learning some of the different things that are being required for the different products, what we require versus what HUD requires. But some of the things that we're finding out is that when you're dealing with a HUD product, HUD holds certain parties responsible for different aspects of construction from start to finish, from the manufacturer to the installation of the home. But one thing that I thought was interesting is that what HUD requires when it comes to an installation is if the factory hires the installer, even if the installer messes up something, the factory is being held responsible for the corrections of that installation. The other thing is if a seller was contracted to hire the installer and the seller hired the installer, the seller would be held responsible for the corrections of the installation. The other thing too is that when you read the HUD requirements, they have quite a few different definitions for installation, but they come out of different sections of their installation guidelines. And so there's a specific section in the construction standards that mentions installation, but that talks about the installation of the products within the home so that the home can be compliant with the construction standards. And then the second part to the installation is actual installation of the home at the site location, putting it on a foundation system and doing the structural connections. So when they're talking about installation, you have to be really careful of what part of the installation they're talking about. But the similarities between our program and HUD's program is, we have specific individuals that are responsible for each phase of construction from start to finish. So the way we handle our complaints is if there is an issue with the construction, we reach out to the factory and give them a correction notice if there's any. If there's anything wrong with the installation, the actual setting of the home and making those structural connections, we reach out to the installer because they're the one that did the work. And now where it gets a little tricky is when the seller is contracted by the manufacturer to finish the work at the site location. Although you were contracted to do that work, we ultimately go to the person who's ultimately responsible for it, and that would be the factory. So where this kind of gets a little, comes up a lot, I guess, is when it comes to the OC process or on-site construction process. So sometimes a item or a few items cannot be installed at the factory to complete the compliance of the structure, and it needs to be done at the site location, and that's what's on the OC form. But the seller is usually the one who's out on site, and they hire a general contractor or they hire somebody to finish that work at the site location. And sometimes when we go out and do these inspections for those OC items, there's issues, right? And so who gets that correction notice? And you would think maybe the seller would, because they're the one who hired the contractor, but per our statutes and our rules, it doesn't go to the seller, it goes back to the factory, right? And we have to sit there with the factory, and they're like, well, we contracted with the seller to do that, and we understand that, but that was a contract that was between those two parties, and not between what the statute requires for that factory to do. So we reached out back to the factory. And in those cases, sometimes we involve the seller because the seller is doing the work. So we'll have conversations with the factory and the seller, or the factory and the installer, just to make sure, like, hey, let's try to work this out civilly without having to take this to court. But at the end of the day, if the seller's unwilling to finish the contract what they had with the factory has to fix it, and the factory will have to take the seller to court for violations of their contract. And so I kind of just want to make you all aware of that, just because that's something that we're having to deal with quite often, at least in the recent months, because there's quite a few complaints that are coming up, and the homeowners are saying, well, the seller, or they'll mention the company, but it's actually the seller, and they're like, well, they're not finishing the product, this is not done. And then when we send a correction notice to the factory, they're like, well, it's not the factory's fault. And it's, well, we understand that, but they're the ones who's ultimately responsible for that. So it gets a little tricky. All I ask is you do what you can to get what you can done for the customer. But if it gets a little too complicated for you, please reach out to us, because we can assist you with that and have those conversations with not only you, but the factory and the homeowner if needed. Because I think a lot of complaints that we're getting now actually are involving lawyers, and the lawyers are asking a lot of questions, and we're having to explain the same process to them. Hopefully that kind of puts that little seed in your head.
Donnie, those are good points. And to put it into a more concrete example, the most recent problem was a skirting problem, right? Who's responsible for putting on the skirting? Is it the manufacturer or the seller or the installer? It gets, the responsible parties on that gets really, on these type of things gets really weird.
Yep. Another big one is grading, right?
Oh yeah, the grading, yep.
Yep. Who's responsible for grading? That seems like a site developed item, just like a foundation system, or any kind of infrastructure that's being done at the site location. But if you're talking about HUD, it specifically says siting, setting, and the structural connection of the structure, right, for an installation. And that siting, S-I-T-I-N-G, is the actual scoping of the piece of property that you're placing the structure on. So if grading is needed a certain way, it needs to be done during that installation of the structure, which is falls under the installer's responsibilities. So that's something that we had to get clarified with HUD, because it was one of those gray areas of who's doing it. Is it the installation for the construction of the home, or is it the installation for the setting of the home? Right? Because like I said, if you look at the HUD's requirements, there's three of them. There's three sections there: 3282, 3285, and I believe 3286. And so in 3286 is the overall installation of a home. That involves the installation of whatever needs to be completed for the home to be used, and then the installation of the actual structure on a foundation system, and then connection from unit to unit. I advise you, if you do sell HUD products, to look at that, because at the end of the day, when we get a HUD complaint, since we don't have any HUD factories here in the state of Colorado, we send the HUD complaint that's specific to the factory related issues to the state agency, the SAA, from where that product comes from. And what they're going to do is they're going to look at the contracts and see who was the responsible party for those items. And then, so ultimately, you as a seller, if you're contracted to do that, you're going to be held responsible for it. And I think the last thing you want to do is violate any federal standards. And so just be, I guess, cautious about the work that you're signing on to do, and the work that you're going to complete.
Thank you, Donnie. Any other questions on complaints? Audits, contract requirements, bonding?
I wanted to show them real quick the insignias. The new insignias, and then I guess we can just run a quick overview of all the insignias, just in case the seller's not familiar with what needs to be on what. So I'm not sure how you have your screen set up, but it might be more helpful if you set it up so that all the chat or all the videos are on the side and then one big screen. But hopefully you can see this on a small screen. But this is the insignia that Sam was talking about for our tiny home. So it's the technical color is like a magenta, but we call it pink. So it's like a pink metallic insignia. And this is the new insignia that's going to go on tiny homes when tiny homes start being built. This is a certification that you will see on those structures if you were to sell them. Okay. I think most tiny homes are going to be certified at the factory, because it's just going to be basically built and sold from the factory. I'm not sure if tiny home builders are going to be building and selling to a dealer, but if they are, chances are it may not have this until after it goes to a destination. But we'll have to discuss that a little bit more when we get into those scenarios. But right now, this is the new insignia. We haven't placed this on yet, so we're still waiting for the tiny home program to kick off, and so we can start placing those insignias on Colorado state regulated tiny homes. The other thing that we added is this gold color insignia. So it's different from our copper colored insignia. So hopefully you can tell the difference between the two. This is the copper, and then this is the gold. But this gold insignia is going to be on all multifamily installations. And so when a structure or when a complete multifamily's installation has been completed and certified, it will receive this gold insignia. All right. One thing that we did change is multifamilies will no longer get blue insignias. They're going to start getting these black insignias. These black insignias are for multifamily structures only. So every dwelling within a multifamily structure will receive a primary insignia, and then any additional box to complete that dwelling will get a black floor tag. It's very similar how we do our residential buildings. If you are, let's say it's a 3-box home, you get 1 primary and 2 floor tags. So it's one for the just one of the boxes, the primary for one of the boxes, and then 2 floor tags for the additional boxes. And then we have these older ones that we've been using for some time now. These are blue. Hopefully you can see that. These are for commercial structures only, non-multifamily buildings. These are specifically for commercials like B occupancies, M's, S's, anything other than R's. Okay. And then same process. If it's a 3-box office structure, you get 1 primary, and then you'll get these floor tags. These are new. The floor tags are new. We used to put primaries on every box. Now we're going to put a primary and a floor tag for each additional box. All right. And then again, the copper colored ones, these are for the installation of the home, which is one thing probably should talk about, is that this is probably one of the most common issues that we're running into, is that an installation insignia is not on a structure and the home is getting CO'd by the locals, right? So it's very important that a structure should not be CO'd or go through the local inspection process without getting this insignia placed on the home prior to that. This signifies that the home was installed correctly, and there shouldn't be anything else that needs to be done to set it at the site location. Okay. And then this is another residential. So these are for our IRC homes. These are for the townhomes and duplexes that are built to the IRC codes. So this silver insignia signifies that the structure was completed for the construction compliance, and there's nothing else needed to complete or to do work on that home. Okay, so this is another insignia that should be on that residential structure prior to a CO. So if you're a seller and you're the one who's doing all the on-site work for the completion of the home, before you schedule a final building inspection with the locals, you should make sure that you have both the copper colored insignia and the silver colored insignia. Okay. A lot of locals are starting to catch on to the process and learning what is required from us prior to any occupation of that home. And so some of them are actually kicking back final inspections. They're like, hey, we're not going to do this until we see these insignias. Some get a little confused about it because they'll say like, hey, you don't have the silver insignia on the home for us to release utilities. That's not what we ask. All we ask is that before utilities are released, that this copper insignia is installed on the home. Okay. That just means to us that if it's installed, it's not going to move, right? Because if we inspected it and it shows compliance. If it doesn't show compliance, the structure may have to move, right? So it wouldn't make sense to connect utilities if you're going to have to move the structure. All right. Some of you won't deal with these ones. These are purple insignias. They are for the components. So that's more related to commercial work. One example of a component would be the new Lutheran hospital that they're doing right there on 70. Or is it 70 or right before when 76 turns into Highway 70, there's the hospital that they're building right there. They built a bunch of bathroom groups. So it's not the entire structure. They just built a small component of that entire building. So those components will receive the purple insignias. The other one that we have is these green insignias. These they almost look like our floor tags, but these are inspection only insignias. So we use these ones for products that are leaving the state, that are going to another state, right? We have agreements with other states that we will inspect units for them, and sometimes they give us insignias to place on them. But in order for them to know that we actually looked at them, we'll place that little green insignia on there. All right, this is that silver floor tag. So like I explained earlier, one primary silver insignia will go on one box. And then for any additional box it will receive a silver floor tag. And the last one is a modification insignia. So this is just that a structure was certified in the past, but they wanted to do some modifications, maybe the floor plan changes. And so instead of taking off that insignia and placing a new insignia, we would just place this insignia and then state what the dang plan approval was for it, right? So what that modification was. Okay. If it was like a complete, let's say it was a residential building, like a single family dwelling that they wanted to convert into an office space, then that would probably just get a new insignia because it's no longer a residential IRC building. It's going to be a commercial building. So we would probably take off that old insignia and replace it with the blue insignia. All right. That's all I have on the insignias. Is there any questions, I guess, on that?
Yeah, thanks, Donnie. Any questions for Donnie or myself or anybody else on the team? All right, well, great. I'm going to end the recording. Thank you all for participating. We'll get this up on the website. And again, please remember, we're here to help you be successful. Please call us with any questions or concerns, or you just want to talk through something. We'll get you a call back and try to resolve your issues as quickly as we can. Thank you.